right. All right. Let us begin. We're starting now our look at online contracting, and our first topic is offer and acceptance. And let me get the video camera a little closer there, and let's start. Our first case we'll look at is, sorry, we didn't share on Zoom. There we go. Our first case we'll look at is Spect versus Netscape. This is one of the leading cases about offer and acceptance online. We start with offer and acceptance because that is where the discussion started of online contracting in the courts and in the law reviews with the commentators. So natural to begin there, and there are a number of important cases, but critical are the two that we will look at. Spect being the first one. So the law is the one we learned from our view of standard form contracting. That doesn't change, right? An offer is a manifestation of a willingness to enter a bargain, so made as to justify the offeree in thinking his or her assent will conclude the bargain. And we had our examples of that, of offline contracting, or our example, one of the first ones was, of course, the kindergarten bully, and then Lefkowitz versus Great Minneapolis Surplus Stores, with in both cases, the terms presented right faced in your face. Here are the terms, nothing is left out. You can see it all. Do you want it or not want it, right? That's the characteristic way in which it's taught in schools, and the courts tend to think of it. As we noted, actually consumer contracting, even offline, isn't like that. It's the paper in the box that you don't see until after the purchase is the characteristic pattern of offline contracting. So now we're going to turn similar fact pattern, not the same, similar in online contracting. Now that paper in the box, which was the agreement between you and the manufacturer, becomes the terms of use agreement or privacy policy or terms of sale agreement, accessible via hyperlink on the home page. So we still have the same general definition of an offer, and we have the general agreement here on what's required in consumer contracting for something to be an offer, even when the paper's in the box or it's behind the hyperlink online. It has to be true that a reasonable website visitor, or in the case of offline purchases, the reasonable consumer, would be on notice. Constructive notice, if you want, right? A reasonable consumer would know, may not actually know, but would on reflection realize, or actually does know, either one, right? A reasonable website visitor would be on notice. Again, either if they thought about it, they'd realize, that's constructive notice, or they actually do realize, that's actual notice. Either one, right? What are they on notice of? They're being invited to enter a contractual relationship on the terms accessible via the hyperlink, or as we said in the offline case, expressed in the piece of paper in the box. So we still have that. There's general agreement on that. And what we want to know is that condition fulfilled in, jumped one, is that condition fulfilled in online contracting? Now let's start with an analogy. I use this one a lot when I teach on-site. I actually put the note on the door, but imagine in an on-site classroom, I put a note on the lower right-hand side of the door to the classroom where I know nobody's going to look. And the note says, by entering this room, you agree to pay Richard Warner $100 for the lecture. Sadly, no one has ever paid me. Everybody immediately recognizes this is not enforceable. Technically, the question to see why it's not enforceable, is this an offer? Well, let's go back to our requirement. Right here they are. we don't have a reasonable website visitor in this case, but we have the reasonable student entering the room. And would a reasonable student entering the room think, or on reflection think, gee, there's probably a note on the lower right-hand side of the door that has a charge for the lecture. And once you ask the question, of course, the answer is obvious. No, students don't think that, right? There never are notes on the bottom right-hand side of the door or anywhere that say how much the lecture costs. Nobody would expect that, and that can't be an offer. Let's make our slides a little nicer so we keep them nice and neat. If we need to go back to them. And so that's why the notice on the door is not an offer. It doesn't meet our basic requirement. So what we'd like to know, is this like the note on the door? This is the typical situation when we go online. You know the pattern. You scroll down and down and down and down and down and down and down the homepage, and then you get to some extremely tiny little print that says privacy policy, terms of use agreement, maybe terms of sale agreement. This is from the Wall Street Journal, and you have to go way down their homepage to find this, and it isn't as big as it looks on the slide, right? It's smaller, but you see here are the various contractual terms. These are the various contractual terms that govern your use of their website. And is that like the note or not? And there are two views, right? One, this is no, not like this view, no, not like the note, which we actually find in Speck versus Netscape. That's my view. I'm quite certain that's the correct view, although often Speck versus Netscape is interpreted the other way. We'll talk about that. But Speck versus Netscape says, no, presence of a hyperlink is enough for constructive notice. The presence of the hyperlink should make a reasonable website visitor think, gee, I'm being invited to enter a contractual relationship. Or if they don't actually explicitly think that, they're on constructive notice, because if they thought about it, they'd think that, right? So Speck says hyperlink enough. Sorry, not yeah. Condetto when it confused. The no was for not like the door. Yes, hyperlink enough. No, not like the door. And this is yes like the door. No, hyperlink not enough, right? Another influential court has said the presence of the hyperlink not enough. So we'll look at both these cases. I am strongly myself in favor of this approach, as I'll explain, but there are two approaches, and we'll look at them both. But we'll start with Speck versus Netscape. So here are the facts. Netscape, by the way, well, not just by the way, you need to know. Netscape was the dominant browser at the time of this case, turn of the century, 2000s, early 2000s. And it was, now instead of Chrome or Mozilla or Edge, people were using Netscape. Most people did. In Microsoft's browser, that then called Internet Explorer, was far, far behind. And Netscape was seen as the heroic little company that was successfully battling the monopoly of Microsoft. So people liked Netscape. And so Netscape, they're using the browser, and Netscape says, and we've done another good thing for you. Besides being the little company battling the big monopoly of Microsoft, we're going to solve another of your problems. And they did that with a piece of software that you could download called Smart Download. Now, to understand that Smart Download, you need to understand the conditions around the time. Let's get rid of that. Conditions around the time, right? People, internet connection was slow. It was still over modems primarily. And the so the modem, if you remember, translated the digital signal of the computer into the analog signal of the traditional telephone system, sent the analog signal over the telephone system to an internet service provider. At this time, America Online was the large one in the US, where another bank of modems translated that analog signal back into a digital signal and then sent you out onto the internet. The system was not terribly reliable and you got cut off a lot of the time. That's why the joke at the time was WWW wasn't really for World Wide Web, it was for worldwide wait. So Smart Download says, we're going to solve a problem that this unreliability creates. And the problem was that if we were downloading a big file, like a big graphics file or big video file, especially if you're downloading a whole movie, it would take a very long time, and chances are good that you would lose your connection over that really long period. And when you lost the connection, you had to completely start the download over. Smart Download, so Netscape says Smart Download solves that problem. Install Smart Download, and you can install this, browse with Smart Download and on your websites, and you can, if you do get cut off in your download, you just go back onto Netscape, start up your browser again, and you can pick up where you left off. I assume, they don't explain, I assume Netscape kept a copy of your progress of the download and stored it in a way that allowed you to pick up where you'd been cut off. So that's what here's Smart Download, download it, you can do this wonderful thing. The other thing that happened when you download a Smart Download was that you also downloaded software that allowed Netscape to track you from website to website to website for purposes of sending you advertising. And that the agreement to be tracked was in the terms of use agreement that governed the download and use of Smart Download. But where was that terms of use agreement? Where was the hyperlink to it? And it's just like we looked before. You have to go down and down and down and down and down the web page, right? Way down, just like if we did with the Wall Street Journal, to get to the terms of use. So it looks like this again, right? We got the same situation. It looks like this. So that's the presentation, and the question in spec is this enough for an offer? And it's just the question that worried us earlier when we were talking about Stephen, and I said it would come up again online, right? It's a question about this requirement of the definition of an offer, or if you translate it into our other terms, this question. Is there a manifestation of a willingness to enter a bargain, right? Do you get enough of a presentation to put a reasonable web visitor on notice they're being asked to enter a contractual agreement? That's the question. We got our point of general agreement again. I just thought I'd put it in a slide again. We're general agreement on this. So let's look at what the court says, inspect about that issue. Is this requirement fulfilled? And the judge in this case is Sotomayor. When she was a federal appeals court judge, Sotomayor is now on the Supreme Court. Very good, now already very famous judge. But this is an appeals court decision by Sotomayor. So her conception of the case is exactly like ours, the one we were just talking about in the slides and in this video. She says we're asked to determine whether plaintiffs, specs, acting upon defendant's invitation to download the software, Netscape's invitation to download the software, agreed to be bound by the software license terms, even though plaintiffs, specs, could not have learned of those terms unless they'd scrolled down to a screen located below the download button. So in other words, is this enough for a manifestation of a willingness to enter a bargain? Equivalently enough to put a reasonable website visitor on notice that he or she is being invited to enter a contractual relationship. And you can see, and she continues, she a little later on in the case, she says, well, look, a consumer's clicking on a download button doesn't communicate assent to contractual terms. Not enough for a manifestation, not enough to put a reasonable website visitor on notice if the offer or the presentation of the button and the text did not make clear to the consumer that clicking on the download button would signify assent to those terms. Translated into our language about an offer, I take it that means is not being enough. That's not enough for an offer, right? Because you have to have the offer presented. So again, her picture is just again, is there enough of a presentation, a manifestation of a willingness to enter a bargain to make people think, gee, I'm being asked to enter a contractual relationship? And she says, in this case, no. She says, we are not persuaded that a reasonably prudent offeree in these circumstances would have known of the existence of the license terms. This seemingly harmless little qualification we'll come back to, because I think that matters a great deal. But she says, no, not in these circumstances. And so our question is, why does she say no? Why does she say that? Now, if you read about SPECT versus Netscape in the commentaries and online, there's a very, very good chance that you'll hear just what we were talking about. You'll read just what we were talking about, and this will be the explanation of why she says no. The commentators seem to love to quote this sentence. Why no? Because plaintiffs were responding to an offer that did not carry an immediately visible notice of the existence of license terms or require an ambiguous manifestation of assent to those terms. So she says, right? Look, it's like the problem is this. Here's the button, and way, way down here, where not visible from the button, are the terms. That's what she seems to say. But that if you think about it, that can't be right. She can't mean that. That can't be what Sotomayor is trying to say, because think about the consequence. It'd have two consequences. Would be in the sale of non-digital goods, offline contracts, there are almost no offers, because is the offer immediately visible when you buy an offline good? No, it's in the box, like my story about the Polish hairdryer. You see it after you purchase. It's not immediately visible. That was the whole issue in Pro CD versus Zeidenberg. But as the court points out in Pro CD versus Zeidenberg, that hasn't bothered us for 100 years. We've been thinking it's fine not to have it immediately visible. So our practice of over 100 years would just be wrong. That can't be right. That is the court's point in Pro CD versus Zeidenberg. Look, we've been doing this for 100 years and it's working. Nobody's complained too much. it can't be that a not immediately visible offer, a visible piece of paper or not immediately visible hyperlink means that there's no offer, right? Because that would mean almost no website succeeds in making an offer. Think about what it would mean for the web. Think about all the sites you go to. Almost all the sites you go to are like this. Are like this, just like this, right? You scroll down and down and down, and there are the terms. Right, so there's the point. And more elaborately, I got a little ahead of myself about non-digital consumers goods after purchase. You see it after purchase. And the point we didn't say yet was, why do we do it this way? Right, as we emphasized a little earlier, custom and practice. That was the point when we talked about the restatement. Said, yeah, but consumers know they're being invited to enter a contractual relationship. When we concluded our discussion of offline contracting, we concluded it with a discussion of the UCC and the restatement. And we said, and the restatement should say, look, everybody knows when you're buying the toaster, hairdryer, microwave, whatever, there's a paper in the box that's the contract. You know you're being invited to enter a contractual relationship. And to that extent, you have constructive notice of the terms. And we filled that out with our discussion of norms that lie in the background and govern the transaction. So it works for non-digital goods. So if you look more fully at what the court actually says, what Sotomayor actually says, you see that there are two parts to what she says. Here's the part about not immediately visible. But then she amplifies that with this. What bothers Sotomayor at the appeals court level is indeed what bothered the court at the trial court at that level. It's not just that the terms, the hyperlink isn't immediately visible. The whole setting and presentation tends to conceal the fact that there is a terms of use agreement at all, right? Netscape makes it look like this is just a free download with no strings attached. Download it for free. A good thing it does is you can pick up your downloads where you got cut off if you get cut off, and that's it. That's what's the whole setting and the time, the fact that it's Netscape, the turn of the century context, the way it's presented, the language that surrounds it, the whole context tends to conceal the fact that you're being invited to enter a contractual relationship. That makes it like my note, right? So if that's true, then it is like my note. But that, right? So I think that's the way to interpret Sotomayor. It's not just that it's not immediately visible, it's the surrounding context in which gave it a tendency to conceal. Right? It's the surrounding context that does that, not just the fact that it's not immediately visible. And so let's go back to this. Is this like SPECT, right? Think back to our Wall Street Journal example, or in almost any website you've been to. Does this presentation tend to conceal you're being invited to enter a contractual relationship? I'd say no. It's not like the note on the door. The note on the door works because there's no custom and practice of expecting terms to be posted there. The paper in the box in offline contracting works because there is a custom and practice of expecting a contract to be in there. Now, who doesn't know that there are hyperlinks with legal terms and conditions at the bottom of web pages? In 2020, who doesn't know that? And if there's somebody that doesn't know that, they should know that as a reasonable website visitor, right? Because our requirement is not just that the website visitor actually know, is that a reasonable website visitor know that. And in 2020, what reasonable website visitor doesn't know that there are terms and conditions at the bottom of the web page behind a hyperlink? I can't think everybody knows that, right? We do have the custom and practice. So the way I interpret SPECT is that this is sufficient for an offer unless the context is such that this presentation tends to conceal that the person is being invited to enter a contractual relationship. And that is what was really wrong with this presentation. The context, the surrounding language made this look like a free giveaway, no strings attached. It's not, again, it's not just that you have to go down there to see the terms, right? It's that given the way it's presented, you wouldn't expect there to be terms down there. But when we visit websites, we're used to this. We expect the terms to be down there. So that's why I interpret, here we go, SPECT versus Netscape this way. Oops, cut the run. That way. And that, in the end, will be the view I propose. I think that's the correct view, but we'll turn to the opposite view in the next video, the view of Nguyen versus Barnes and Noble, which takes the opposite position. So we'll want to see, well, what is there to be said for the opposite position? And then we'll make up our minds. Okay, we're done with this video. Let me stop this.